is something else I feel compelled to address in this case, and that is the behavior of the prosecution, which, in my personal opinion, has been juvenile and unbecoming of professionals who are paid public money to serve as ministers of justice, not just as advocates in a public court of law. Let's look at what our cameras caught in court.
One might think the gravity of the deaths of 4 people or the gravity of seeking to put a man to death warranted the prosecution's full attention. Apparently, it did not. During defense closing arguments, prosecutor Sean Doherty felt the need to text someone as the defense presented the most critical argument which can ever be delivered in an American courtroom, an argument to spare a man's life.
This decision is not based on revenge.
With buzzwords like decorum and professionalism in the legal community, ask yourself, does this conduct by the prosecutor stand up to those expectations? The texting went on for approximately 10 minutes in full view of the jury. At one point, prosecutor Doherty appeared to share a laugh with Detective Ryan Smith as the defense tried to focus the jury on whether defendant Merritt should live or die. I personally don't think it's a laughing matter.
This is the case of the People versus Charles Merritt. This is not a case against Sean Doherty, Britt Imes, Melissa Rodriguez, despite the fact that we've been attacked constantly throughout it.
During closing arguments in the first phase of this case, prosecutor Melissa Rodriguez slammed the defense, but she never apologized at any point for the time she turned her back to the bench and crossed her arms in apparent disgust during a judge's ruling. The jury was not present for this, but still, what message does this body language communicate to the community? Does it send the message that the prosecutor thinks she's smarter than the judge, or maybe that she thinks she's above the law? Even in the heat of argument, should this behavior be acceptable in any court proceeding? Ask yourself that. Though Chase Merritt was the man on trial, the prosecution carries the burden, remember that as well. And at several points during this trial, the jury was present for head shaking by the state during critical moments of the defense argument. Ask yourself, is this a distraction for the jury? Does it unfairly take away from what the defense is arguing? Does it take away from the defendant's right to a fair trial? Does it deflect the burden away from the state? Does it turn accusation into fact? Does it create a due process issue under the Fifth Amendment? The Founding Fathers refused to give the government the power to take a man's liberty or his life easily, because a system which allows swift, easy punishment can easily be abused. Despite unknown DNA in the victims' graves found by the defense and which the prosecution refuses to test, prosecutors successfully convinced the jury that Chase Merritt was guilty beyond a reasonable doubt.
We, the jury, in the above entitled action, find the defendant guilty of the offense of murder.
Maybe the jury doubted the defense case because the prosecution's behavior distracted the jury away from following the defense witnesses or the defense arguments, just maybe. And if this jury was lulled into a sense of disbelief toward the defense by a prosecution whose job it is to shoulder the burden in a criminal case, then the ramifications for justice are disturbing. Now, in the name of fairness, I have asked the prosecutor's office for comment on these matters. None thus far has been forthcoming. That is my opinion. Let's see what the panel thinks. Judge Ashley Wilcott joining us from Georgia. Judge Wilcott, would this happen in your courtroom? Why or why not?
Well, here's the thing, Aaron. Could it happen once? Absolutely. We're all human. Trial attorneys are human. The problem I have is that it's happened more than once. If I were to observe as the judge on a case that this type of behavior was occurring more than once by a prosecution or a defense, I would be very even-handed. I would tend to call them up outside of the presence of the jury to explain courtroom decorum, to let them know if there's an emergency they need to text about, they need to let me know that. Otherwise, I would not expect nor accept continued behavior like this in my courtroom.
Former federal prosecutor Gene Rossi, your opinions on this. Did you text in court, Gene, when the defense was giving an argument to try to save a defendant from some punishment when you were a prosecutor?
The courthouse where I rolled, they didn't allow your texts in the courthouse. But when I did go to courthouses with my phone, I never text. And there's a judge named T.S. Ellis III. He did the Paul Manafort case. And if you made any faces, if you grimaced or used any body language that was disrespectful, he would admonish you in front of the jury the first time. He wouldn't give you one bite at the apple.
Okay, Linda Kenny Bodden, you defend Accuse criminals in court. If you're the defense attorney up there and that behavior is going on, how big of a distraction is it? Is this as serious as I take it?
Yes, you call it out. And remember, I know you don't like Casey Anthony, and some of our viewers don't like my co-counsel then, Jose Baez. But remember, he called one of the prosecutors out. When I was a prosecutor, we were taught you don't want to show very much interest, okay, in the other side, but you never show disrespect. So you can kind of sit there and you kind of look down. Maybe you can write a few notes, but you don't laugh unless there's something that everybody is laughing about.
You don't roll your eyes. You don't distract. You don't try to give some sense that whoever's on the stand might be lying by shaking your head in the middle of it. So ultimately, how does this thing land? Ashley Wilcott, we've got about a minute left here. Do you think it's possible this could have affected the outcome?
Well, I do, because to me, if you're watching that as a juror, you may think either A, oh, we shouldn't even take the defense seriously, or B, that it's a laughing matter, that the seriousness of what the jury has to do doesn't exist. So I do think it's an issue that could affect the outcome of this case.
In just a few seconds, Gene Rossi, your thoughts.
I blame the judge too, because a good judge, not the 8-ball judge that I call him, would have admonished those attorneys to stop what they were doing.
Okay, those are our opinions, the three of us. I hope that we're well informed enough to be able to speak on this matters. We've got a judge here. We've got a criminal defense attorney here. We've got a former federal prosecutor here. Appreciate the insights in the panel, and thank those of you for watching us here on The Debrief tonight. Our live trial coverage will pick up at 9 o'clock in the morning Eastern Time here on the Law and Crime Network. The Debrief will be back live tomorrow at 5 p.m. Good night.